I think we'll go ahead and get started. So, first, everybody, please make sure you're on mute, just so that we don't get all the background noises. Welcome to our 2020 virtual employee meeting. I so wish that we could all be together in person. I know it's not quite the same, but we're meeting virtually this year, obviously, to ensure everybody's health and safety. But still wonderful to see everybody's faces. I'd like to quickly introduce our executive team. I'm Nick Berg, the president of CitiScape. Also on the call, we have our vice president, Paul Mora, our chief operating officer, Robin Romo, our chief financial officer, Wayne Lee, our co-founders, Kevin Wiley and Ed Dale, the president of Reliant, Mark Owens, our CitiScape Director of Operations, Francis Serrano, and our Director of Residential Real Estate at Fog City, Rebecca Gloyd. So I think everybody knows 2020 has been quite a year. We're currently engaged in maintaining our client communities through a global pandemic.
Yes.
I think we can all agree this has been a really difficult year. Managers have had to adapt to doing meetings on Zoom as opposed to in person. Our custodial crews have had to adopt PPE and do enhanced COVID cleaning. Our on-site staff, God bless our on-site staff, they have had to shut down amenities, change the way that we do club rooms and pools and gyms. And then also they've had to absorb a lot of frustration and anger from homeowners and residents who are sheltered in place and, dealing with their own private struggles. And then of course, our Reliant construction managers have shown incredible resiliency. I don't know if you know this, but construction in March and April was completely shut down. We're basically back to where we were before, which is incredible. So I just want to say, I'm incredibly proud of the way that everybody has responded to the pandemic and has pivoted and that you've gotten through this year so far. You've made a huge difference to your communities and to CitiScape. CitiScape, Fog City, and Reliant remain strong. We are going to get through this together. So again, I just want to express my appreciation and thanks. Quick housekeeping. So again, please make sure you're on mute. Mute button, if you don't know, is on the lower left-hand corner of your screen. It says mute. Meeting is being recorded. So some people can't actually be on this call right now. So we are recording it so that they can view the presentations later. Just want to disclose that. We still want to encourage you to offer any comments or questions. Just want to make sure that you know that that is going to be recorded and it's going to be on the recording that goes out to everybody. It will be a shortened meeting this year. We have a representative from Paychecks to do our mandatory annual harassment training. Everybody should have received in the mail a workbook, the harassment workbook. We are going to need you to fill that out and return it to Capri. Because we're doing this virtually, the workbook, the completed workbook that's signed by you serves as evidence that you completed the training. So if you don't complete it, it's going to track you down. So go ahead and get in front of that and get it in. Okay, I think we go ahead and get going again. So I would like to introduce Courtney Falk of Paychecks, and she is going to do our annual harassment training.
Awesome. Thanks so much, Nick. So welcome everyone to your annual sexual harassment and abusive conduct prevention training. As we go through this training, I want to remind you that the information included in this seminar is considered best practice, should not be considered legal advice under particular situations. So that being said, we're going to start off today with a little bit of related federal and California case law. So just to give you a little background on sexual harassment and how we've gotten to where we are today, these related case laws really have come into play to have established exactly what is sexual harassment and what is a violation of the law under both federal and state requirements here in California. So the first one is Meriter Savings Bank versus Vinson. This happened in 1986, and for the first time in 1986, this court case determined that sexual harassment is a violation of Title VII of the Civil Rights Act. So prior to 1986, sexual harassment wasn't a violation of the law. So it doesn't seem like it was that too far ago to me. But in 1998, we had On-Call versus Sundowner Offshore Services, in which they determined that same-sex sexual harassment is also a violation of the law. In Harris versus Forklift Systems in 1993, for the first time we established that hostile work environment is also a violation of the sexual harassment laws. In addition to hostile work environment, that means that an employee doesn't have to experience harm from an employment standpoint, but rather more psychological harm in the workplace is a violation of the law. In Farragher versus City of Boca Raton, in this particular case, Farragher actually filed a harassment claim against the City of Boca Raton. Boca Raton had done their training, they investigated the situation, they took appropriate action against the individual who contributed to harassment in the workplace. And in this particular law, at the federal level, they determined that the City of Boca Raton could eliminate any liability because they took appropriate action. However, at the State Department of Health Services versus Superior Court in California in 2003, they kind of voided out Farragher versus City of Boca Raton and said the employer is always liable. Even if they take appropriate action, they can still be held liable for sexual harassment in the workplace. In Bostock versus Clayton County, Georgia in 2020, do you believe it? This year, this particular law or this particular case was settled. And it said that in this particular case, the Clayton County, Georgia actually terminated individuals based on it being transgender and sexual orientation. So as a result, in this particular case, it determined that you cannot terminate employees due to transgender or sexual orientation. So that was a good step. Finally, in 2020, we got that one. The other two cases in California law, Lyle versus Warner Brothers Television Productions. In this particular case, I find this very interesting because Lyle was a writer on the TV show Friends and charged Warner Brothers with sexual harassment during the writing process of Friends. They determined that the situation was rife with sexual innuendos and things of that nature. Well, Warner Brothers argued that in the light of the storyline of Friends, that this was necessary for the creative process. And in this particular case, Warner Brothers actually won this case against Lyle. So that was an interesting little twist thrown in to California law. We also have Hughes versus Pear in 2009. And in this particular case, Hughes and Pear had a very professional working relationship for many, many years when all of a sudden Hughes accused Pear of specific sexual harassment that occurred on one occasion. Well, in this particular case, the city of, or the court actually decided that although you had a professional relationship for many, many years, one instance of sexual harassment does not necessarily constitute an actionable case. So another good one for California. All right, so a few things as we go through today. Remember, California does have a requirement to provide all employees with sexual harassment and abusive conduct training once every 2 years. 1 hour for non-managerial employees and 2 hours for all managerial employees. So this is going to cover 1 hour for your employees as well as the first hour for your managerial employees. Now, during this training, we're going to talk about harassment, what it is, what are protected classes, who's protected by the law, and who can be held liable, as well as different types of discrimination. We'll review the key concepts and legal definitions of sexual harassment, talk about the types of sexual harassment that occur in the workplace, and what abusive conduct is, what employers need to do to avoid abusive conduct in the workplace. We'll finish up by talking about what you should do in the event that you have been harassed or witnessed harassment, and also retaliation in the workplace. So what's the big deal? You may be asking yourself now, what's the big deal? We are a family organization, we joke around, we have fun, but the big deal is that harassment affects more than just the victim. Harassment affects others who have to pick up the slack. Maybe I'm calling in sick more frequently as a result of being treated unfairly in the workplace, or a work environment that is not comfortable for me to be in. Harassment can also affect the company as a whole, both from a reputational and a financial standpoint. So the big deal is that everyone has a responsibility to keep harassment out of our workplace, and we all need to do our part. Okay. When it comes to sexual harassment in California, sexual harassment is a form of employment discrimination that is based on sex or gender, gender identity, gender expression, or sexual orientation. So keep that in mind as we're going through this today. Sexual harassment is not just she's asked me out on a date every single day for the last 3 months, but rather it could be based on sex or gender, gender identity, expression, or sexual orientation. Now, when it comes to unlawful discrimination, there's 2 types of discrimination. We have direct discrimination within an organization where we have employment decisions that are made based on a protected class status. So who we hire, who we fire, who gets promoted, and things of that nature can be considered discrimination in the workplace. The other type of discrimination is known as adverse impact. Now, adverse impact occurs when you have an employment policy or procedure that, while it appears to be discriminatory on its surface, or it appears to be neutral on the surface, actually has the underlying effect of being discriminatory. So now when we talk about protected classes, we have a lot of different protected classes at the state and federal level. Now at the federal level, the Equal Employment Opportunity Commission has issued some protected classes. So we have things like the Age Discrimination in Employment Act that prohibits discrimination on the basis of age for those individuals who are age 40 or older. We have the Americans with Disabilities Act that prohibits discrimination on the basis of disability, which could be either a physical or mental impairment that substantially limits major life function. We have GINA, the Genetic Information Non-Disclosure Act, that prohibits us from discriminating against individuals based on their genetic makeup. And of course, we have the Civil Rights Act of 1964 that just prohibits discrimination on the basis of national origin, race, color, religion, and sex. There's also the Pregnancy Discrimination Act, which amends the Civil Rights Act that prohibits discrimination on the basis of pregnancy or childbirth. We also have veteran status, which is a federally protected class as well. And then, of course, based on the case law this year, we have transgender and sexual orientation. Now, here in California, we take all of those protected classes and we kick them up a notch. So again, age, ancestry, color, religious creed, including religious dress and grooming practices. We also have disability, which is physical or mental, also including HIV and AIDS. Marital status, medical condition, genetic characteristics, national origin, race, sex, gender, gender identity or expression, sexual orientation, military or veteran status, and any other protected class under California or local laws. So in California, there are 17 different protected classes. So now a few things. The Fair Employment and Housing Council actually has defined these terms for us to understand when it comes to gender in the workplace. So gender is an individual's sex assigned at birth. So this is either male or female. Transgender is a person whose gender identity differs from their sex assigned at birth. So gender identity is my internal understanding and an identification with a particular gender. So this is where gender becomes very fluid. It can include male or female, a combination of male and female, neither male nor female, or transgender. We also have gender expression. This is how I express myself to the world. This could be through my behaviors, my clothing, or any other characteristics. Now, when it comes to transgender rights in the workplace, this is Senate Bill 396. It does say that we need to include some harassment training that provides some guidance and support for a respectful work environment for LGBT employees. So who is protected by the law in California? Now, under the federal law, we have employees who are protected as well as applicants. But here in California, we also protect clients, unpaid interns and volunteers, and any persons providing services pursuant to a contract in the workplace. And it's written specifically like that into the law. So anyone you can come in contact with is protected by our sexual harassment laws here in California. Now, who is liable under the law? Under California, every employer or prospective employer is liable under the law. And every person in the workplace, including managers, supervisors, subordinates, coworkers, we can all be held and found liable for sexual harassment and personally liable for damages caused by unlawful harassment. So we all have a responsibility in the workplace to act professionally and treat others with dignity and respect. All right, so here we go. This is gonna be in your workbook. So make sure that you pull out your workbooks. If you don't have one, contact Capri, she'll send one to you right away. These need to be completed as we go through. So, true or false? Volunteers and unpaid interns are not protected against sexual harassment. Everybody got their answer? The answer is false. So absolutely, volunteers and unpaid interns are protected by the law here in California. All right. Oh, I went a little bit fast there. All right. Individuals can be held personally liable for sexual harassment. Got a little happy with the button. That one is also true. So remember, as individuals in the workplace, we can all be held personally liable for sexual harassment. California law identifies 17 protected classes for employment discrimination, harassment, and retaliation. We covered this one. That one is true. All right, so let's talk a little bit more specifically about the types of discrimination that can occur in the workplace. So when it comes to types of discrimination, there are three main types of discrimination. We have differential treatment, unintentional discrimination, and harassment. All right, we'll get into those in a minute, but the non-discrimination principles and prohibiting discrimination in the workplace applies to all aspects of the employment relationship. So this includes hiring, training, promotions, who gets certain work assignments, who gets transferred, how much people get paid, layoffs, discipline, terminations, as well as the working conditions in general. So are we separating our employees? Are we keeping them in different areas based on a protected class? Okay. All right, so remember, when it comes to working conditions, it's really important that we provide a work environment where employees do not feel intimidated, unfairly treated, or segregated from others based on their membership in a protected class. So let's talk about those different types of discrimination. First and foremost, we have differential treatment. This is an employment policy when an employer makes a employment decision based on a protected class. So if we decide Courtney's getting up there, let's not send her to training because she's going to retire soon, that could be seen as differential treatment based on age. We also have unintentional discrimination. Now, unintentional discrimination is also known as adverse impact, and this is an employment policy or procedure that, while it appears to be neutral on the surface, has an underlying effect of being discriminatory. So the example I always use for this one is back in the day, they used to require firefighters to be at least 5'9". We want our firefighters tall and strong and manly. But the reality is that someone who is 5'8", 5'7", 5'6", or even more petite than that definitely can be a good firefighter. So this had the unintentional effect of discriminating against women because women tend to be shorter than 5'9", where I think the average height for men is 5'9". And the last type of discrimination is harassment. So this is if someone is abusing, insulting, or otherwise harming an individual on a regular basis, it could be considered harassment. So sometimes this is annoying, sometimes it's cruel, and in some cases, it's even illegal. All right, so here's your first scenario. Tom is a model employee who is called by Sue to mentor and train new employees. The last time a promotional opportunity has come up, Tom applied, but the promotion was given to one of the female employees Tom has trained. Tom being discriminated? Maybe. It could be a discrimination claim based on gender, but we really need to find out a little bit. All right, so true or false? California FEHA prohibits discrimination and harassment based on several protected characteristics in addition to the protected characteristics under federal law. The answer to that is true. Here in California, we have additional protected classes that are not included at the federal level. So what does FEHA stand for? The Federal Employment and Housing Act, the Fair Employment and Housing Act, the Federal Employer and Housing Act, or the Fair Employer and Housing Act. This one is B, the Fair Employment and Housing Act. It is specific to California. This is not a federal agency. It is a California agency. Now, which of the following is a potential negative impact of workplace harassment? Decreased morale, loss of productivity, tarnished company reputation, or all of the above? That one is all of the above. True or false? California FEHA prohibits discrimination and harassment based on several protected classes and characteristics in addition to the protected characteristics under federal law. This is true. Which term best describes a situation where an employee is a victim of discrimination, including harassment, and the conditions are so bad that he is compelled to resign? Now, we didn't cover this quite yet, but this is constructive discharge. So when it comes to constructive discharge in the workplace, that means that my work environment is so rife with harassment or discrimination that an employee would feel compelled to resign. All right, now when it comes to unlawful harassment is unwelcome conduct that's based on a protected class when enduring this offensive conduct becomes a condition of continued employment, or if the conduct is so severe and pervasive that it creates a work environment that a reasonable person would consider intimidating, hostile, or abusive. So in these particular cases, remember that unlawful harassment could be an ongoing, occur over a long period of time, or if the situation is severe enough, it could just be one incident that could rise to the level of unlawful harassment. Now, it's important to note when it comes to harassment that your standards of conduct and behavior could be considered harassment, and it can be adjusted based on claims and case laws that are heard in courts. So this is a very, the actual definition of unlawful harassment is very fluid. Now, while illegal harassment is a form of discrimination, not all discrimination claims are necessarily considered harassment. So remember, harassment is that unwelcome conduct that's based on a protected class. So think back to our example of Tom. He's a model employee who is relied upon by his manager, Sue, to mentor and train new employees. The last 3 times a promotional opportunity has come up, Tom applied, but the promotion was given to one of the female employees Tom has trained. Now, while this situation could be considered discrimination, you may have a clear case for discrimination in the workplace. Is this scenario considered harassment? And again, we'll probably need some more information to determine whether or not it could be considered harassment. But we'll get back to Tom in a minute. Now, when it comes to the definition of sexual harassment, remember, harassment can be based on any protected class at the state or federal level. But when it comes to sexual harassment, that's a little bit different. So the EEOC, or the Equal Employment Opportunity Commission, has defined sexual harassment as unwelcome sexual advances, any requests for sexual favors, any other verbal or physical conduct of a sexual nature, when the conduct explicitly or implicitly affects the individual's employment, if it unreasonably interferes with an individual's work performance, or if it creates an intimidating, hostile, or offensive work environment. Now, the FEHA defines sexual harassment as harassment based on sex or of a sexual nature, gender identity, gender expression, or sexual orientation, gender harassment, or harassment based on pregnancy, childbirth, or related medical conditions. So remember, when it comes to our California definition, it's a little bit more broad. So the definition of sexual harassment can include many forms, including offensive behavior and same-sex sexual harassment. So the Department of Fair Employment and Housing has distributed pamphlets on what is sexual harassment as well as discrimination. There's a poster out there as well that should be in your work site. Now, when it comes to sexual harassment, here are a few things that I want you to remember as we go through. So remember, sexual harassment can occur between individuals of the same sex, and sexual desire is not required. It could be a power trip that one person has over another individual. And adverse employment action is also not required. So adverse employment action is that I got fired or disciplined because I refused to comply with a sexual request. Okay, so just to make sure you're paying attention, true or false, sexual desire is a key element to any claim of sexual harassment. That is, of course, false. An employee can file a claim of sexual harassment even if the supervisor took no adverse employment action, in other words, termination, failure to hire, demotion, against an employee. That is true. All right, so we're going to go through sexual harassment and the different types of sexual harassment a little bit right now. Now, there are 2 types of sexual harassment: quid pro quo and hostile work environment. So here's a quick scenario. Michael asks his administrative assistant, Christian, to stay late and work on a special project. When they are alone, Michael makes sexual advances towards Christian. Christian tells him that he has a boyfriend and he is not interested. Michael continues to pressure Christian, telling him that he can kiss his career goodbye if he won't comply with his requests. Now, that is a clear example of quid pro quo. Now, quid pro quo is Latin for this, for that. You do this for me, I do that for you. Now, this is when sexual favors are demanded in return for a tangible employment benefit. It can be expressed or it can be implied. And in this particular case, it was expressed that he could kiss his career goodbye. Now, quid pro quo is generally done from a manager or supervisor to a subordinate employee. It is a power trip. It is exhibiting that power over another individual. So someone who has control over your employment or could have control over your employment could be the harasser in this particular case. Okay. All right. So remember Tom from our previous scenario? What if Tom had an email from his manager stating that he would get the promotion if he went out on a date with her? Now that seems more like quid pro quo harassment to me. Okay. So Blake is the sole proprietor of Acme Company. He has decided to expand and compete for state contracts. Blake hires Jack, an independent contractor, to install a computer network. Blake threatens to sue Jack for breach of conduct unless Jack agrees to engage in sexual activity. So which of the following statements is true? Jack can't sue Blake because he's an independent contractor. Jack can't sue Blake because Acme Company has fewer than 5 employees. Jack can't sue Blake because he's a man. Or Jack can sue Blake for quid pro quo sexual harassment. D is correct. Remember, California law protects independent contractors and any employer, even if you just have one employee or sole proprietorship, are subject to our sexual harassment laws here in California. All right, who is the typical perpetrator of quid pro quo sexual harassment? Remember, it's a manager or supervisor, someone in authority or perceived authority towards the employee. True or false, quid pro quo sexual harassment can be based on a single, isolated, one-time only, never happened before event. This is true. So depending on the severity, if I was terminated as a result of not complying with my manager's sexual request, I could sue for quid pro quo sexual harassment based on one event. All right, the other type of sexual harassment is hostile work environment. Now, hostile work environment occurs when an employee is forced to work in a hostile, intimidating, or offensive work environment, where protected individuals are subject to unwelcome, gender-based sexual conduct that is pervasive and severe enough to alter the terms or condition of employment. Now, when it comes to hostile work environment, this means that the conduct needs to be sufficiently severe or pervasive that it alters the term of employment. So this is based on the reasonable person standard here in California. That is, would a reasonable person find the behavior sufficiently severe and pervasive that it alters the terms of employment? And the courts have determined that a reasonable person is a person who has an ordinary degree of reason, prudence, care, foresight, or intelligence, whose conduct, conclusion, or expectation in relation to a particular circumstance or fact is used as an objective standard by which to measure or determine something. So that's our court's way of saying that there is a certain level of harassment or a certain level that you have to meet in order for it to be considered hostile work environment. Now, some other considerations: the nature of the conduct. What exactly happened? The frequency of the conduct. How frequently does this happen? Is it a daily occurrence or was it a one-time thing? The period of time over which it occurred. Again, that's kind of along the lines of frequency. Is this something that happened once? Is it something that happened over a 3-year period? And whether the conduct was physically threatening or humiliating, and the extent to which the conduct unreasonably interfered with an employee's work performance. So does a hostile work environment have to be caused by a manager? Absolutely not. All of us as employees can contribute to a hostile work environment in the workplace. So here's an example. Megan is a customer service rep at a wholesale distributor. Jim, an employee of one of her company's biggest customers, comes into the distribution center weekly to pick up orders. When he does, he always waits for Megan to be available so she can wait on him. For some time, Megan hasn't thought anything of her interactions with Jim. They might joke or flirt a little when he comes in, but that's really all it was. But recently, Jim asked Megan out on a date. Megan said no, telling Jim that she was in a committed relationship and not interested in dating anyone else. But Jim isn't taking no for an answer. Every week, he asks her if she's ready to go out with him. Megan is tired of having to tell Jim no, and although she has mentioned her concerns to her supervisor, she doesn't want to keep complaining since Jim's company is a very important customer. So could this be an example of unlawful sexual harassment here in California? Yeah, it could. All right, so now the courts have recognized 3 different types of hostile work environment. So the 3 different types here in California include conduct that's directed at the claimant. So that is you, the conduct is directed at you. Another type of hostile work environment is conduct that's directed at others that you are witnessing, or widespread sexual favoritism in the workplace. Now, when it comes to harassing conduct, this can include verbal, visual, or physical harassment in the workplace. Now, verbal harassment could include foul, obscene language, derogatory comments, innuendos, explicit discussions about sexual activities, or comments about a person's physical attributes. Visual harassment could include things like leering, staring, making sexual gestures, displaying sexually explicit objects, pictures, cartoons, graffitis, or posters, or sending emails, texts, messages, or jokes through your email system or even social media. Physical harassment could include things like kissing, hugging, grabbing, impeding or blocking movement, or assault. So I always used to say the only physical conduct that should occur in the workplace is a handshake or a fist bump. But now in these days of COVID-19, let's just wave at each other from more than 6 feet away. All right. You and Chris have been good friends for 3 years. You've dated on several occasions. Last week, Chris was promoted to director. Chris is not your direct supervisor, but the head of your division. Chris stops by your office and asks you to dinner. Concerned about how having dinner with a new director may look, you decline. Chris leans over your desk and states that if you want to be promoted to supervisor, it's in your best interest to go to dinner. Is this situation quid pro quo, this for that, or hostile work environment? This situation is quid pro quo. He's asked you to dinner and has told you that if you don't go out to dinner with them, you will not be promoted to supervisor. All right, your work area is a back office operation that's pretty hectic. Men and women both refer to each other using derogatory terms. One of your coworkers visits a website every morning and shouts out a joke of the day, which is always of a sexual nature. Now, most of the workers participate, but a few seem uncomfortable. Is this situation quid pro quo or hostile work environment? So in this particular case, this one is hostile work environment. So it's really important to be aware of your coworkers and their level of comfort with behavior. In this case, these types of things are definitely not safe for work and should not be allowed in the workplace. All right, true or false, to prove hostile work environment sexual harassment, the complaining party does not need to show that they suffered an adverse employment action. This is true. Remember, hostile work environment does not necessarily have an adverse employment action. Now, to prove hostile work environment sexual harassment, the complaining party must show that they were subject to unwanted sexual attention that is both severe and pervasive. This is false. So keep that in mind as well. You don't necessarily need to prove that to prove a hostile work environment and sexual harassment. Now remember, there's so many different things when it comes to conduct that could be considered unlawful in the workplace. But remember, there's rules to the workplace. Just like there's rules to the golf course and there's rules to the basketball court, there's rules to the workplace. And what's acceptable with your friends out on a Friday night may not necessarily be acceptable at work. So some of these things could be considered unlawful sexual harassment, but this is not an all-inclusive list. So things like sexually offensive jokes, pictures, or sexual comments, rude treatment of women or men because of their gender, including same-sex sexual harassment, unwanted invitations, notes, or flirtations. Perhaps it's gossip, rumors, or other discussions or speculations of an employee's sexual orientation or gender identity. Maybe it's sex as an implied condition for promotion, or harassment after the breakup of a relationship between employees. Now remember, sexual harassment can be verbal, nonverbal, or physical. So some examples of nonverbal sexual harassment could be emails with sexually suggestive messages or pornographic pictures. This could also include instant messages or social media interaction, even on your own personal computer outside of the workplace and work environment. Could also include physical harassment, touching, massaging, invasion of a personal space, physical assault, impeding someone's progress, or leering or elevator eyes. Remember, the elevator eyes are looking someone up and down. All right, true or false, a male employee can be the victim of sexual harassment. Sure hope you guys got this one by now. This one is true. All employees can be a victim of sexual harassment without regard to gender. Unlawful harassment can occur where both individuals are the same sex. This in California is also true. All right, so here's an example of what could be considered harassment and sexual harassment, what may not be considered sexual harassment. So Pete and Angela work together in the finance department. They both enjoy listening to the same genre of music. Pete asks Angela if she'd like to go with him to a concert. Angela thanks Pete for the invitation, but tells him she's not interested in going out with him. And that's the end of the conversation. That is not considered sexual harassment. So does sexual desire have to be an underlying reason for sexual harassment? Absolutely not in California. Is asking a coworker out on a date considered sexual harassment? No. However, remember, no means no. Now, when it comes to abusive conduct here in California, I want to cover a little bit about what abusive conduct is. Now, abusive conduct is malicious conduct of an employer or an employee in the workplace that a reasonable person would find hostile, offensive, and unrelated to the employer's legitimate business interests. Now, abusive conduct can be verbal or physical, could include things like repeated infliction of verbal abuse, such as derogatory remarks, insults, threats, intimidation, humiliation, or epithet, or the gratuitous sabotage or undermining of a person's work performance. Now, you may think abusive conduct sounds suspiciously similar to harassment, but remember, harassment is a form of employment discrimination that is defined as unwelcome conduct that is based on a protected class, whereby abusive conduct is hostile, offensive, or malicious behaviors that are intended to humiliate, threaten, or intimidate someone. The biggest difference? Unlawful harassment is based on a protected class. Abusive conduct may not be. All right, so what is the Latin phrase used when a person of authority demands sexual favors in return for a promotion or other job-related benefit? Quid pro quo, pro bono, ad quod damnum, or pro tempore? This one, of course, is quid pro quo. It almost seems like a sexual harassment cliche these days, but it does exist. All right, true or false, under California state law, an employee, applicant, unpaid intern, volunteer, or persons providing services pursuant to a contract in the workplace can create a hostile work environment. This is true. How does the Fair Employment and Housing Council define gender identity? Is gender identity a person's internal understanding of and identification with a gender? Is it an individual's sex assigned at birth? Or is it a person's gender-related appearance or behavior? Or is it all of the above? Trick question with this one. This one is a person's internal understanding of and identification with a gender. Remember, gender identity is fluid. All right, so what should you do if you feel that you have been harassed in the workplace? Immediately tell the alleged harasser that the behavior is unacceptable and unwelcome. We want to empower you to be able to say something in these situations whereby you can tell someone if they are making you feel uncomfortable. However, if you're unable to confront the alleged harasser or if the unwelcome behavior continues, you should report the incident to one of the people indicated in your company's no harassment policy. Now, if you witness harassment or become aware of potential instances of harassment, you should report it to your supervisor, manager, or the person designated in your no harassment policy. Your notification is essential. We want you to come forward and talk to us in the event that you feel you have been harassed in the workplace. Now, there are some different things that we can do as individuals to avoid and keep harassment out of our workplace. Now, when it comes to bystander intervention, what do we do if we see somebody being harassed in the workplace? Now, bystander is a person who witnesses sexual harassment. Maybe it wasn't directed at me, but I do witness a harassment in the workplace. A victim is a person who has been sexually harassed in the workplace. And an ally is a person who believes sexual harassment is wrong, supports victims, and takes action to stop harassment. Now remember, all employees have the right to work in a harassment-free workplace. We all have a right to be treated professionally with dignity and respect in the workplace. And I want you all to be empowered to be allies in the workplace. So some things you can do to be an ally: confront the harasser. If you witness it, say, hey, you know what? You just attended Courtney's training. That is not okay in the workplace. Be an ally to the victim. Make sure you document what you see and support the victim in reporting it to their supervisor or the person in your harassment policies. You can also interrupt or distract the harasser. Sometimes that is really all it takes for it to stop, or at least in that particular situation, to stop. And then be a good ally and follow up with the victim. Say, hey, remember last week when this happened? Did you talk to somebody about that situation? Make sure that you can get it to stop for them. So there are some best practices for all of us as employees to prevent harassment in the workplace. First and foremost, we are responsible for our own actions. So avoid engaging in any behavior that could be considered harassment. Avoid engaging in behavior that could be considered demeaning, embarrassing, or offensive to others. It has no place at CitiScape. You should also correct harassment situations by acting in a prompt, fair, and confidential manner. So if you see anything, make sure that we're addressing it. We're not just turning a blind eye. It takes all of us to prevent harassment in the workplace. And be aware of your behavior towards any employee who may have complained of harassment in the past. We all have a right to work in a harassment-free environment and to be treated with respect and dignity. And remember, the fact that someone files a complaint of harassment does not mean that they are disloyal to the team. It means that they need and, quite frankly, deserve to work in a positive work environment. And CitiScape is committed to protecting the confidentiality of employees who report unlawful harassment to the extent possible. We will conduct investigations when harassment is reported as well. So what are some remedies for victims of harassment? So any employees, applicants, unpaid interns or volunteers, or persons providing services pursuant to a contract in the workplace, you feel that you've been subjected to harassment in the workplace, you can take any of these following steps to remedy the situation. We'd like you to first and foremost follow the company's internal complaint procedures. Report the act immediately to one of the persons indicated in your company's no harassment policy. You can also contact the Equal Employment Opportunity Commission or the Department of Fair Employment and Housing. Now, under the law, there are some remedies for victims of harassment. This could include things like injunctive relief, such as training development or changes in policies or procedures. We saw this happen not that long ago to Uber. They had some new training requirements and culture changes that they had to go through with regards to harassment in their workplace. There could also be some economic damages, so reimbursement for lost wages or benefits, medical expenses, or even job search expenses. There could be non-economic damages, so reimbursement for emotional distress or loss of enjoyment of life, hiring or reinstatement, reasonable accommodation, or recovery of attorney's fees. There could also be considered some compensatory damages, so reimbursement for out-of-pocket expenses or for any emotional harm suffered, and punitive damages. This is a punishment to ensure that it doesn't occur again in the future. And of course, liquidated damages equal to the amount of back pay awarded. So remember, there is a statute of limitations for victims of harassment in the workplace. With the EEOC, this is a federal guideline. It needs to occur within 180 calendar days from the last day that discrimination took place. So the 180 calendar day filing deadline is extended to 300 days if a state or local agency enforces the law that prohibits employment discrimination on the same basis. So that can be extended here in California as well. And with the DFEH, it needs to occur within 3 years of the date of the alleged violation. Now, we do have some resources for victims of abusive conduct. Now, it's important if you do witness abusive conduct, abusive conduct is not a violation of the law in California unless it rises to the level of harassment. Remember, abusive conduct is workplace bullying that is not necessarily based on a protected class. So we do have some resources for you. There's an employee assistance program that you can access that will include qualified counselors, crisis intervention, management consultation and support, and additional training programs. We also have our employee handbook policies. So your EEO statement and no harassment policy, your open door policy, employee relations philosophy, or a policy against workplace violence. These are all there to protect employees from abusive conduct. We also have additional management and employee training. Now, when it comes to retaliation in the workplace, we've talked a little bit about retaliation, but all the laws that prohibit discrimination and harassment in the workplace also prohibit retaliation. Now, remember, it is illegal to retaliate against people, either applicants or employees, because they filed a charge of discrimination, because they complained to their employer or other covered entity about discrimination, or because they participated in an employment discrimination proceeding, such as an investigation or lawsuit. Now, retaliation can include many different things. It can include things such as dismissal or demotion. It could include a transfer, a change of job responsibilities without justification, or a change in work location, maybe a negative evaluation or a decrease in pay rate. Now, all of these things are typically done from a supervisor or person in a position of power down to a subordinate employee. But we as employees can also retaliate against other employees. So things like spreading rumors, threats, things of that nature could also be considered retaliation and contribute to a hostile work environment. And remember, all of us can be held liable for harassment in the workplace. So we all need to do our part to ensure that retaliation does not exist. So if an employee feels that they are being retaliated against, you should immediately report it to the persons designated in your company's no harassment policy. We have zero tolerance for retaliation in the workplace, and we will handle those situations as well. All right, so here we go. Which of the following might be awarded as a remedy to a victim of employment discrimination? Back pay, training, policy changes, or all of these? And of course, is all of these. How long from the date of alleged violation of the California Fair Employment and Housing Act may an employee file a complaint with the California Department of Fair Employment and Housing? Is it 90 days, 1 year, 180 days, or 3 years? What is the statute of limitations? Here in California, it's 3 years. True or false? If you observe harassment taking place in the workplace, it is best to let the people involved resolve it between themselves. It's none of your business. This, of course, is false. We want you to be an ally. We want you to step in. We want you to talk to us in the event that you have witnessed harassment in the workplace. If you honestly do not intend to offend anyone, your behavior cannot be considered harassment. This is also false. Remember, it is not the intent of the harasser that counts, but the impact that that behavior has on the recipient. So someone's innocent joke or comment that was intended to be funny may actually constitute a form of illegal harassment. Now, if someone lets you know that your behavior makes them uncomfortable, you should stop that behavior immediately and not engage in that behavior again. This, of course, is true. So in this particular case, do be aware of your behavior towards individuals who have complained of that behavior, have complained of harassment in the past. It is all of our responsibilities to act in a professional manner at work and treat our coworkers and colleagues with dignity and respect. Fill in the blank. If an employee witnesses a potential harassment situation, A, he should approach the alleged harasser. B, he should try and console the employee being harassed. C, he must report the situation as directed in the company's no harassment policy or problem-solving process. Or D, he should mind his own business and do nothing. So this one is C, but it wouldn't hurt to approach the alleged harasser, maybe interrupt them. You can also talk to the employee who is being harassed and encourage them to contact the person noted in your non-harassment policy as well. But definitely, you must report the situation as directed in the company's no harassment policy and problem-solving process. Remember, your notification to us is essential to resolve. All right, so during this training, we talked about harassment in protected classes, who is protected by the law and who could be held liable, which is all of us. We discussed the different types of discrimination. We reviewed some key concepts and legal definitions when it comes to sexual harassment. We talked about the types of sexual harassment, both quid pro quo and hostile work environment. We reviewed abusive conduct and talked about what we need to do in the event that we've been harassed or witnessed harassment in the workplace. We didn't talk too much about the investigation process other than the fact that the employer will investigate any claims of harassment, and we talked about retaliation. All right, so I'll open it up to any questions or comments, and I see a few things actually came through.
Yeah, Courtney, people had questions about the scenario on page 3.
Yeah.
So I think the question was, is the scenario considered, could it be considered harassment?
So you'd really need to find out more information about the particular situation before it could be considered harassment. But in the event that he did receive an email from his supervisor saying that he would get the promotion if he went out on a date with her, then yes, it could be considered harassment.
Got it. So we're going true, could be harassment depending on the circumstances.
Correct.
All right. Are there any other questions? Please go ahead and take yourself off mute or put it in the chat. Do you have any questions for Courtney? All right. Well, Courtney, thank you so much. I want everybody to know, so CitiScape, we try really hard, and we've put a lot of work into setting the right tone and having a good culture. So please do let us know if there's an incident of harassment. I believe the designated persons in our harassment policy are Capri and the members of the executive management team. So me, Robin, Paul, Wayne, Ed, Francis, Mark Owens, just, you know, there's a lot of people that you can go to here. Okay. If there's nothing else, thank you guys so much for attending today's annual employee meeting. That is it. We're going to dismiss everybody. Hang in there, courage, and thank you guys so much.